All rise. First District Court of Appeal is now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We have one case before the court today. Global Hookah Distributors, Inc. versus Department of Business and Professional Regulation. Is the appellant ready to proceed?
Yes, Your Honor.
You may.
May I approach?
You may. Now, these are consolidated cases, but I don't see any reason for you to bifurcate the argument, right?
I agree, Your Honor. Thank you. Good afternoon. May it please the court. My name is Gerald Danini. I'm here with James McCauley on behalf of the appellant Global Hookah Distributors. I'd like to reserve 4 minutes for rebuttal, please. Your Honors, both final orders in this consolidated case should be reversed because hookah tobacco is not clearly within the definition of a taxable tobacco product under 210.25. 210.25 is a taxing statute with specific and precise terms, which are to be narrowly construed, and pursuant to that section, to be a tobacco product for tax purposes, this product must unequivocally be 1, loose tobacco, and 2, suitable for smoking. This product is neither. And to reach that conclusion, that this is a taxable tobacco product, requires interpretation beyond the statutory text, resulting in illegal taxation by implication.
So part of that definition talks about snuff, plug, and twist tobacco. We're not talking about that part of the definition.
Just loose tobacco suitable
Just
for
loose
smoking.
tobacco
Correct.
suitable for smoking.
That's
Okay.
correct.
Okay.
Now, with respect to
Why do you think the legislature is obsessed with tobacco? Like, tobacco gets its own chapter for taxation. So what do you think it is about tobacco?
What is it about tobacco that it gets its own section? Like,
Yeah. What's so special about tobacco and while you're at it, alcohol?
yeah.
What do you think it is about tobacco?
Well, I think they wanted to, to discourage like a certain behavior, have a really high tax on it.
What
So,
kind of behavior specifically?
like using those products. It's like almost like some states refer to it as like a sin tax.
Right.
So.
And what is it about tobacco in particular that contributes to that? Is there something in the tobacco that causes people to want to use it a lot?
I would say that tobacco is an addictive product, is my understanding,
Yeah.
and then
what
it has like
aspect
harmful.
what
I'm sorry.
aspect of the tobacco is addictive?
The nicotine, I believe.
Okay,
Yeah.
right. And that's why, according to, is it Dr. Louderman or whatever his
Right.
name was.
The department's expert.
Yeah, didn't he say, and I don't know if you disagree, that the reason that tobacco is in this product at all, in the hookah, is for the nicotine?
I think that was part of the record. He did say that. It's a very, very trace amount of nicotine in this product. I think that's
But then
correct.
why have it at all? I mean, why have the tobacco? You can just have the glycol
Yeah.
and the other stuff, the flavor and all that kind of stuff, and just huff, glycol
Right.
vapor or whatever, I don't know all the
Right. I follow.
terms specifically, but you get the idea.
Right. I think the record evidence does say that part of the reason for the tobacco being in there is the nicotine.
Right. And isn't that the reason why the snuff's in the list, so, you got your snuff and your chew and all this other stuff in the list, or the definition of tobacco product? Not all of it's smoked, and some of it, you put it in your mouth, but isn't there a common element in all of that? Is the reason why people use tobacco?
I think that's correct, Your
Isn't it
Honor.
for the
Yes, If
nicotine?
I follow, for the
Right.
nicotine, right.
And so isn't that true for the hookah as well, for this product? That
Right.
it's a delivery system for nicotine?
I think that's correct, Your Honor. I think there's some social pleasure aspect to using this particular product. All of that said, though.
So the device that they use to consume this hookah tobacco that they call hookah tobacco, is called a pipe, a hookah pipe.
A hookah
right?
pipe, right,
Okay.
right.
That sounds like smoking to me.
Yeah. Going back and forth a little bit, so the same can be said about the blunt wraps at issue in both the brandies and grab leaf cases. Those were made of tobacco as well. So respectfully, Your Honor, I don't think the test is whether there's tobacco in the product. In fact, that argument was expressly rejected in the brandies case. The court said
Both
that.
of those cases hinged on whether the tobacco was loose.
That's
So in the one
correct.
case, you had the stuff that was, I guess, chopped up tobacco mixed with wood
Paper.
dust and pressed into a sheet of paper.
That's right.
That you used to wrap.
That was the brandies case, that's
Okay.
correct.
And this court said that that was not loose tobacco.
That was not loose tobacco.
And then the department said, okay, we interpret, the court is saying that, this mass of something that's made up that looks like paper, but a single leaf tobacco, we're gonna regulate that. We're gonna tax that.
So if you're talking about the grab-a-leaf case, that was like a purely 100% tobacco leaf blunt wrap, and the court said that was not loose tobacco either.
Yeah.
So this case turns on whether this product is loose tobacco suitable for smoking, not whether there's tobacco as a constituent ingredient in the product.
Okay, so your argument is it's not loose?
It's not loose.
And it's not smoky?
That's correct, Your Honor.
Okay, so let's talk about loose.
Sure.
In the record, there's a bunch of pictures of the hookah product.
Yes, Your
and
Honor.
it looks like a cake, kind of a
That's fair.
spongy,
Yeah, so it's.
wet kind of cake together.
Right. So it's tobacco that's mixed and heated with other ingredients, namely
Chopped
like
up pretty fine.
chopped up pretty fine.
There was
Mixed.
testimony in the record that you could still see the veins and the leaves.
That's correct.
Okay.
You can still see the pieces of tobacco. It's chopped up. It's heated and mixed with other constituent ingredients such as glycerin and molasses. And then,
So do you leave it together in this cake like this when you put it on the hookah pipe, or do you spread it out? You pull it out to look like its constituent fibers, or does it go on there like this hockey
Somewhere-
puck looking thing?
yeah, right, like somewhere in the middle. So you wouldn't use that whole like cake that you're describing it as. You would take like a clump of it, I think is how it was described in the record. So that clump contains tobacco and those other ingredients. You put the clump of it into the hookah device and consume it that way.
Okay, but your argument on suitable for smoking end is that it's heated, but it's never lit on fire.
That's right.
And it's not consumed.
That's exactly right, Your Honor.
Okay.
With respect to suitable for
Well,
smoking?
So on the suitable for smoking part.
Right.
So I know it's a different part of the chapter, you're talking about cigarettes.
Right,
If you, smoking a cigarette, it's not the exhaust of the combustion that gets you the high from the nicotine, right?
I'm not sure, Your Honor. I know the distinction is between a cigarette and this product is that with a cigarette, you actually, directly light the tobacco.
That's right.
Yeah, this product is a heat not burn product as it was determined by
Right,
the.
but assume for a moment, because this
Right.
is the same with the whole marijuana discussion. So, smoking marijuana, it's not the marijuana smoke, it's not the burning of the leaf that gets you high. It's the vaporization of the THC in the leaf that gets you high. And so when I was asking you before about the nicotine,
Right.
I'm having a hard time figuring out the difference between, if it's all a delivery vehicle, and so the only difference between smoking a cigarette or burning the tobacco and inhaling the exhaust from that combustion, and this is the manner of heating the target chemical, which is the nicotine in every instance, the manner of heating that nicotine to a high enough temperature so that it vaporizes so that you can inhale it and get it in the bloodstream. So isn't it just kind of a red herring to say, well, this tobacco doesn't combust, it's just heated to the right temperature, just the same as heating a cigarette tobacco is heating it to the right temperature. But in one, you're combusting, and the other one, you're putting it on a heat element
Yeah.
to get to the same outcome, which is a vapor that's going to get you high.
I think I follow your question, Your Honor. To the first point, it's not that you get nicotine from it that's the factor. It's not any tobacco, and that was addressed in the Brandy's case. So the same could be said of the blunt wraps, yet this court held differently in that case, saying that was not a tobacco product because it doesn't meet that specific definition.
Because it wasn't loose. It didn't get into.
It didn't get into
was
it?
suitable for smoking.
Right.
So I'm asking for the purposes of suitable for smoking. You have a
Right.
tobacco leaf product that is every bit of the design of it. It's treated and how it's used is designed to get a high enough heat to get the nicotine out in a vapor that you can inhale.
Right.
But with other stuff that makes it more fun, because who wants to just huff some vapor
Yeah.
that doesn't give you a flavor or that sensation of having smoke in the air and that kind of thing? I mean,
Right.
it's a whole thing, right? I
Right.
mean, that's why people go to hookah lounges.
Right.
If it was just people just sitting around huffing some nicotine vapor, that's not nearly the same social
Yeah.
experience.
So basically, back to loose tobacco. So basically, because only speaking for myself, I'm not sure the suitable for smoking argument is particularly persuasive.
Okay.
But as regarding the loose tobacco, the legislature used the word loose. It indicates to me what they were trying to capture. They may not have done so, and you may be correct. They're trying to capture every tobacco product that is not a cigarette. Would you say that's fair?
I don't agree with that, Your Honor, no.
Why is that?
So again, that came up in the Brandy's case, that in that case, the department was saying, anything made of tobacco or tobacco as constituent ingredient to that product made it a taxable tobacco product. Yet they found that it was not loose tobacco, even though it was made out of tobacco. And the court even said in the Brandy's case that the legislature chose specific verbiage, loose tobacco. That word loose has meaning, and we can't just skip to say anything.
I know it has meaning, that's what I'm asking you. What do you think the purpose and the intent of the statute is?
What is the purpose of the
I
statute?
know that's not a Federalist question. I'm asking you what the intent of the legislature was, God forbid.
I think the intent of the legislature was to tax the products that were available and popular at that time, back in 1985. And back then, they were talking about loose pipe tobacco that you stick in a pipe and smoke it. They were not referring to this product.
Or tobacco you buy and roll in papers.
Right. That would be loose tobacco. Like, for example, if you took a bag of pipe or filler tobacco,
Right.
and that was talked about in the
But
graduate.
isn't that what your product is?
It's not, though.
It's tobacco melded with molasses and other products to be inhaled, consumed, heated. It's certainly suitable for smoking. I guess you can debate the definition of smoking.
Right.
But isn't the overarching purpose of the statute, and again, you have the argument that it has to be interpreted in favor of the taxpayer.
That's correct.
So that's certainly a pretty rigid rule of interpretation.
Right.
But isn't the intent of the statute to capture everything that's not a cigarette?
I don't think that it is, Your Honor, for the reasons I just discussed.
Well,
And-
what do you
and in
think the
addition-
intent, maybe let's try it this way.
Okay.
What do you think the intent of the statute is?
I think the intent of the statute was to tax products available and popular at that time. This product didn't become popular until much later. And if you look at like the licensing statutes and other statutes, they use any tobacco. This says loose tobacco. There was a reason why the legislature chose any tobacco in
So
the
you
licensing.
think it was only to capture products in 1985?
I think that they used loose tobacco because that's describing as is snuff and the other things in the statute. Those are all talking about specific products.
But we wouldn't know that because the only thing you cite in your brief is Merriam-Webster Online from last year, which we know of all the definitions possible, it can't be that the legislature intended the definition that's online from last year as the definition, right? So
Yeah.
wouldn't it have been more helpful to go back to the 1980s, 1985, 86, or 84 even?
Yeah, I'm not-
And pull out articles or to support what you're saying is, well, what they meant back then was X, Y, and Z. They had in mind, everyone, when you mention smoking or loose tobacco, everyone knows it just means the stuff you put in the pipe.
Right. So a couple of comments on that. Everyone, I think, agrees in the briefing, and this court said so in Brandeis, that it's a clear and unambiguous statute. So there's no need
Well,
to.
then why go to the dictionary at all?
Because under cases like Conage, that's, the dictionary is the best evidence of a plain and ordinary meaning of a word or phrase. So.
But not Merriam-Webster Online from last year, right?
I don't know that
A case I've always found interesting regarding statutory interpretation is Bostock versus Clayton County, where the Supreme Court held that a 1964 Civil Rights Act applied to homosexual and transgender characteristics. Even though, obviously, that statute was written in 1964, in fact, at a time when homosexual conduct was illegal in all 50 states, but the court looked to the literal language of the statute to say that it had to be interpreted in the manner the court did. How do you think that type of interpretation applies here?
I apologize, Your Honor, I'm not sure I'm familiar with that case, but are you saying that?
So you're saying, because your argument is the word loose has to be interpreted to exclude our product because it literally can't be dropped with your fingertips. Isn't that's essentially the argument?
That's essentially, I think that's fair, Your Honor, yeah.
But if the statute was intended to capture everything that was not a cigarette,
They could have done that easily by saying
how so?
anything made of tobacco like they did in like the licensing statutes.
Well, we have two cases where we said that something that was actually tobacco
Right,
is not loose tobacco.
It's not
because
loose tobacco.
It's a one-piece thing.
right. And that's the path we went down, both at the hearing and in the briefing, that this is a clear and unambiguous statute. This is the definition used by this court. We apply that definition to this set of facts, and this is the outcome of this case is this product doesn't squarely fit within that taxing statute. Again, taxing statutes are special. They have to be narrowly construed in favor of the taxpayer.
So the blunt wrappers in both Brandy's and Grab-A-Leaf arguably could have been torn into smaller pieces
Of
and made
course,
loose.
yeah. And Brandy's, or Grab-A rather, was literally a 100% tobacco leaf with nothing else. And Brandy's was, like you mentioned before, paper and tobacco mixed together and turned into a blunt wrap. It was cut pieces of tobacco mixed with paper to make a blunt wrap. Applying that dictionary definition, this court said, obviously, that that was not loose tobacco. Likewise here, this product is cut pieces of tobacco mixed with other ingredients to make like this clumpy, cakey mixture, and therefore, because the tobacco, under a plain and ordinary analysis, is attached to other items, so it would not be loose tobacco.
So if you had, excuse me, so if you had loose tobacco, 95% loose tobacco, and you mixed it with some chewing gum, and you put it in a pipe and smoke it, is that taxable?
If it, with chewing gum, I think that would no longer.
95% tobacco,
Yeah.
loose tobacco,
Right.
melded with chewing gum,
think, yeah.
and put in a pipe, is that taxable?
No, Your Honor, I think at that point, the chewing gum makes it no longer loose tobacco.
You think that's a reasonable interpretation of the statute?
Under Brandy's and the definition, I do, Your Honor.
Forget Brandy's, I mean,
Right.
the statute.
The statute says loose, which means attached to other, like, the loose tobacco that the statute's talking about, in my opinion, and I think in the Grab-A-Leaf opinion, is the tobacco, if you were to dump it on this table, it would go all over the place. That's completely unattached, unbound pipe tobacco. This tobacco, if you,
Is that really fair, and is it maybe absurd to say, well, we've mixed our tobacco with some ingredients that are sticky, so you pipe tobacco sellers, you can pay this exorbitant tax, you pay this 25% plus the, I think this is 60 or 85% excise.
it's 85%
Right.
total.
So
right.
you could pay this high tax, we're not gonna pay it because we've mixed it in with an ingredient, and therefore we're out, we're excluded.
Yeah, I mean, I think that's kind of assuming that somebody would do something to avoid the tax, but,
I'm sure nobody ever does that.
no, never,
Right,
never,
right.
yeah.
Can I ask you
So,
one question about, before you use all your rebuttal time?
Yeah.
Actually, he did not ask for any, but we'll
did?
allow, or if he did, 4 more minutes.
I meant to ask for 4 minutes, but I
And 4 minutes
apologize.
for the other side, so they have 24, if they want.
On your unadopted rule challenge.
Right.
Can there be a scenario where, like, just take this case.
Right.
Is it possible for us to say, yeah, the department applied the wrong, they misinterpreted the statute?
Right.
So it's not taxable. But have that not be an unadopted rule? Sorry for the triple negative.
I think,
on that.
so I think what you're saying, Your Honor, if I follow, I think that I do. I think there's 2 paths on this case. The first is, it's clearly within the statute, and if it's clearly within the statute, it's taxable, and the department's literally applying the statute to the product, so a rule is not necessary. The second option, I think, is this product's outside of the statute, and if it's outside of the statute, it would require taxation by implication to bring it back in. So if it's outside of the statute, it's non-taxable, and it also requires an unadopted rule.
Right, but that presumes that they could adopt a rule, right?
That presumes,
Right.
You're saying
If
they
it's
didn't
outside
adopt
the statute, they don't have any authority to adopt a rule and make it taxable. Your argument is, it's not taxable, period.
I think they-
That has to be your argument.
right. Yeah, I think that's right.
So
So
it's
what-
irrelevant whether there's an unadopted rule.
But if they have a policy of general applicability,
Well, they can't have a policy of general applicability that violates a statute.
that violate, I think that is the purpose. I'm sorry if I'm missing
I
your
mean,
question,
your
Your Honor.
primary claim is, look, they're taxing us and they don't have the authority to tax us.
Right. And I
Right?
think if that's,
And that's your primary case. But then you got this separate unadopted rule challenge.
Right.
You're saying, well, because they're taxing us without authority, it's an unadopted rule.
right.
And I don't understand the point. Why go through this? Why have 2 appeals? Why go through the process twice? Like, what's
If
up
you,
with
so, the tax challenge case applies to the refund claim, so that's backward-looking in effect. I think the unadopted rule would secure prospective application going
I
forward.
wondered about that because as I recall, the refund was about 1.5 million or thereabouts.
That's
You've
correct.
continued paying the tax, right?
That's correct, yes.
So if we rule in your favor that it's not loose tobacco, aren't you entitled to a greater refund than that?
Yes, we are,
I think that's the right answer.
yeah. Yeah,
Well,
so,
you're now
right,
into your rebuttal time if you'd like to keep it.
okay, I'll reserve the balance for rebuttal.
May it please the court. Good afternoon. My name is Brooke Adams, and I represent the Appley Division of Alcoholic Beverages and Tobacco. This case comes down to
You might
whether...
want to pull that microphone down a little bit, counsel.
Is this better? Okay. This case comes down to whether hookah tobacco is loose and whether it is suitable for smoking, and the answer to both questions is yes. This court should affirm the final orders for 3 reasons. First, the ALJ properly made findings of fact that the hookah tobacco was loose and suitable for smoking. Second, it properly applied his findings of fact to the law and denied Global Hookah's request for a refund. And finally, the ALJ also properly determined that the division's policy of taxing hookah tobacco as a tobacco product was not an unadopted rule. So first, hookah tobacco is absolutely loose. Global Hookah argues that it's not loose merely because it's mixed with other ingredients. But this argument fails to properly interpret this court's holding in Brandy's product, and it also ignores the definition.
So my hypothetical to your opponent was, excuse me, let's say an enterprising entrepreneur decides to make a product that really packs a punch with nicotine. It's 95% tobacco, but the entrepreneur adds 5% bubble gum, chewing gum. You put that in a pipe, you can't take the tobacco out of it. It's melded in there, sort of like a Star Trek kind of deal or something. You cannot take the tobacco out of the chewing gum pod. You put that chewing gum pod in a pipe. It is smoke, so it meets that criterion. Is that taxable as loose tobacco, in your opinion?
I don't necessarily think so, based on the facts that you just gave me. I think the test here is what this court set out in Brandy's, which was whether a product is densely bound together to make a solid, uniform, cohesive product. If it's like this bubble gum, I'm not sure. I don't think the bubble gum is solid or
So
densely.
I'm looking at the photographs in the record, and this looks like it's a, like a crab cake kind of thing. It's one thing. If you picked it up, it would not fall apart.
So there was actually testimony that it does fall apart when you take it out of its packaging in individual and grouped pieces. And while it is mixed together, it's loosely mixed and it's moist. And there was testimony that when you use it, you sprinkle it into the bowl to be used. So that goes against, it is absolutely not densely bound together to form a solid, uniform, cohesive product.
There's also testimony as to why it is wet, right?
Yes.
And why, what is that reason?
That's so that it doesn't fall through
Right.
the actual hookah pipe when you're trying to smoke it. So
The
that
hole in the
also,
aluminum foil or whatever.
So let's get to the second part, suitable for smoking. So the tobacco product in the hookah pipe is never lit on fire, correct?
that's correct.
And it's set on like a grate where there's heat underneath, but it's heated but never burnt. So it doesn't produce smoke as we know it. It produces a vapor, but not smoke, which is a carbon combustion product, correct? So how does it meet that second part of the test then?
So it meets the second part of the test because, well, first we have the expert witness below who testified that while, the smoke may be different, it's a vapor, the composition is different from the the hookah tobacco smoke as opposed to your traditional cigarette smoke, but it is still smoke nonetheless. So he explained that and testified about that. And then also.
Would you agree with me that, or my proposition, that the whole purpose of this statute, again, heaven forbid we would look at legislative intent and purpose, but I will. The whole purpose and intent of the statute is to capture every product that is not a cigarette.
I agree
To
that.
not allow anybody to avoid the tax simply because it's not wrapped up in a paper with a filter as a finished manufactured nicotine vehicle delivery system, but is in any way contains any tobacco.
I agree, and I agree that the intent was to offset the high healthcare costs that are associated with smoking tobacco and nicotine. So I do agree.
So because the legislature did not know about this product or did not anticipate their product, we should go after the statute and help them and improve their work
I don't necessarily.
to effectuate what they intended to do rather than what they wrote.
I think that hookah tobacco undoubtedly falls within that definition, loose tobacco suitable for smoking, regardless of whether they intended in 1985 to include that product, because,
Or should we ignore legislative intent?
well, the statute here is clear and unambiguous. So, and our argument is that it clearly falls within the definition of loose and suitable for smoking. So if we're still talking about the suitable for smoking, I want to talk about what you brought up, Judge Roberts.
And sometimes courts ignore legislative intent, and they look to the text and they say, in so many words, we don't particularly care about the legislature's intent. But what if the legislature's intent here is very obvious to a disinterested reader? That is to capture every product that's not tobacco, that's not a cigarette.
So I do.
I mean, they did use the word loose. I guess they could have not used that adjective. Is that so?
It does. And if we're talking about legislative intent, I know that there was a bill that was introduced in 2016 where it actually states at the present analysis that hookah is included in loose tobacco suitable for smoking. but even so, it is
So we trying to determine the intent of the legislature in 1985, or what year did you say?
2016.
Or 2016? Oh.
Which is actually still earlier than Merriam-Webster online from last year.
So I guess one of the arguments seems to be, or at least the elephant in the room seems to be, look, we're going to ignore legislative intent. We're going to ignore the purpose of the statute. And we're going to say the legislature every single year in their 60-day session has to get together and change the statutes every single year to capture every innovative use, such as my proposed hypothetical with the 95% tobacco and the bubble gum. By gosh, the legislature better stay on their toes, and every year they better amend the statute to specifically capture that product, because the courts are bound to ignore legislative purpose. Is that an argument you would say is reasonable?
No, I would not. And so going back to the suitable for smoking argument, smoking does not necessarily require combustion. I know we're talking about the most recent dictionary definitions, but one of the definitions of burn is to undergo alteration or destruction by heat or fire.
Why do you have to associate burn with smoke? I mean, why not just define what smoke is?
Exactly.
And
And
isn't smoke broad enough to include, I mean, we think of smoke in a certain way most of the time, but if you really think about it, smoke is actually a broader concept, right?
Exactly. And the definition of smoke is to emit or exhale.
But the department was not able to regulate vape when vape came on the scene. And subsequently, they went to the legislature and said, hey, you need to give us a statute so we can regulate vape. So they did.
Yes,
You know,
and,
they
and
said this water vapor with the nicotine was not smoke, it was vape. So we had to have a statutory change to bring that into the taxation scheme.
And the legislature specifically chose to treat these two products separately. The definition of these e-cigarettes or vapes under the nicotine product part of the statute or the chapter.
So doesn't that support the argument that using a hookah is not smoking?
No, it does not, because these two products are completely different. And
Yeah,
I
isn't there
think,
something missing from vape, from e-cigs? Like a very critical, we've been talking about it
Yes.
for a while. What is that?
tobacco.
Thank you.
They're missing tobacco.
Yeah.
Yes, so both of those products, the e-cigarettes and the tobacco products we're talking about here are completely separate. The e-cigarettes specifically exclude tobacco products from their definition, so we can't compare the two for taxing purposes. The legislature chose to treat those differently. I'm not sure why, but what we have before us is the definition of loose tobacco
Do you think
suitable for
do
smoking.
you think our holding in Gabby Leaf was incorrect?
I don't think it was.
It's okay, you're allowed to say that, if that's what you think.
I don't necessarily think it was incorrect. I think Judge Kelsey's dissent is extremely
I noticed you
informative.
cited the dissent at
Yes,
some
and
length.
she went into great detail analyzing both of the things that we have to analyze here, whether it's loose and suitable for smoking. There, they of course stopped at finding that that the division's policy of issuing that memorandum was an unadopted rule, and they didn't explore whether that particular product was actually loose or suitable for smoking. So that's the reason that I cited dissent, because we have actual analysis there that we can try to use, and so that way we're able to determine whether the hookah tobacco fits within this definition. And so going back,
Since the term loose apparently is, because we have to use the terms together, clear and unambiguous, you never find them separate. Everyone always says the whole phrase, clear and unambiguous. I don't know what it means, but so it is. If loose is clear and unambiguous, what is the antonym of loose?
I would say what this court held in Brandy's, densely bound together to make a solid, uniform, cohesive product. So solid would be the
I
opposite.
mean, isn't the opposite of loose, like bound or confined, that kind of thing?
Solid,
Think
yeah.
like a cigarette is, like that tobacco is bound, right? It's not loose because it's wrapped in something. Would
I
you
can't
agree?
state whether the cigarettes, if they're loose or not, they're specifically excluded from the statute, from the taxing portion.
Well,
that
I mean,
we'll
think about it.
first.
If I'm trying to write a statute, I'm a taxing authority, I'm trying to come up with a way to tax a particular product. And so I have this tobacco, and it's used in a variety of ways, and it's presented in a variety of ways. And one of the main ways it's presented is that god-awful cigarette. You know, they're wrapped, everyone knows what a cigarette is, and they have a particular set of characteristics associated with it. So, okay, we're going to put that in one part of the chapter, and we're going to deal with that separately for whatever reasons. But we got all this other stuff. We have all this other bad tobacco that everyone's addicted to. Everyone wants to inhale it in a variety of ways to get to that nicotine. How are we going to tax that? So wouldn't a fair way to isolate that is to say, okay, stuff that is this tobacco that is loose, as opposed to bound up in a wrapper or something else, that it presents itself in a loose way that you can use in a variety of ways, typically as, I guess, a filler tobacco, right? That you can put it in your own paper. Or let's say you can juice it up with some product that makes it more sticky, and then you can take some of it and put it in some other receptacle. When you say is clear and unambiguous, for loose, the term loose, is that what you're getting at, I guess, at the end?
If I'm understanding your question correctly, I think that hookah still falls within this loose, and I think if the
And why? Equate, this is almost like a logic problem. Like, you have a concept. What are the common elements that make the hookah tobacco like the otherwise loose filler tobacco that people use, and in the movies they sprinkle their the cool guy with his rolling paper, and he sprinkles it in and rolls it up, licks it, and then smokes it. What's the similarity between the two?
So the fact that you can actually see the tobacco leaves in addition to the veins of the tobacco leaves when you look at hookah tobacco, the fact that when you remove it from its packaging, it falls apart, the fact that you have to sprinkle it into the bowl to be used, I think all of those characteristics that the ALJ made findings on demonstrate that it's loose, like the filler tobacco that you just mentioned.
And how is it like or different the other things in the list, say like the chew or the other stuff on the list? Is it similar to or different from?
I think it's similar to, they share similarities and also differences. In that particular statute, it kind of encompasses quite a few different tobacco products, which you had.
So plug tobacco is not loose, correct?
I don't know the answer to
Because
that
if you
question.
take it out of the package, you could shake it, you could throw it on the table, and it would stay in a block.
Sure.
Do you know? Okay.
But
That's all right.
the definition, though, that we have here is that we're only focused on the loose tobacco suitable for smoking. So that's why
Yeah.
our argument is that.
So on the smokeless tobacco, they just had a longer list because there was a lot more variety of that kind of stuff.
Perhaps.
Okay.
But why, but getting back to my original question to appellant's counsel, what motivates anyone to stick some of that stuff in their mouth?
For the nicotine.
Right.
Like we had.
So isn't it fair, you look at that list, what the legislature's doing is taxing an addictive product that the legislature knows people are going to continue using because they like the hit, and we might as well tax them at 85% to get as much out of it as possible. Maybe it deters them, maybe it doesn't, but that is the common denominator across all of it. These are all nicotine delivery systems using tobacco as the source of the nicotine, right?
Yes, that's correct.
So the suitable for smoking, if you look at the loose tobacco, that's potentially distinguishing it from the chew or the other mouth, I don't know how to phrase it, but the other, like the dipping and all the other stuff is to make a
Smokeless
distinction.
tobacco, I think.
Smokeless tobacco. Right?
And arguably, this is smokeless tobacco.
Well, I mean,
If you lit this on fire, would it burn, or would it just go out? That, or that?
I believe
For
there
my
was-
crab cake here.
I believe there was testimony that it can be burned, but that's not the way that it's used by all the users that smoke hookah
But
tobacco.
if you wanted to, it would be suitable.
There was testimony in the record that yes, you could. And so, back to the suitable for smoking, the Supreme Court, the Florida Supreme Court and State versus Brake explained that when a term is undefined in a statute, you apply the term in its plain and ordinary sense. The court also went further to explain that it is permissible to turn to Florida case law in addition to statutory provisions that might be relevant. So in 2012, the Southern District of Florida actually defined hookah tobacco, and they defined it as a type of loose flavored tobacco that is placed within a hookah pipe, which is a device in which smoke passes through a water basin, which the user inhales and exhales.
What court said that?
That was the Southern District of Florida,
And what was
and
the
it was
case?
in Drew Estates Holding versus Fantasia Distribution.
Okay.
And then also in 2012, the same year, the Second District noted in Meek Joe versus DBPR that hookah is smoked in a hookah pipe.
But that wasn't a holding, that was a description and a footnote. That
That's correct.
Didn't really have any moment on the decision in the case.
Correct. But taking those cases together, that helps support the finding that hookah tobacco is in fact suitable for smoking.
Could something be unplain and ordinary?
I'm
Or
sorry?
Could something be plain and unordinary, or unplain and ordinary? Could something be unplain yet ambiguous or unambiguous? Like,
Perhaps-
why the conjunctive phrases, or why use any of these phrases at all? I still don't understand it. The Supreme Court says it, we say it all the time. How does that help the analysis to say this statute is plain and unambiguous? We're going to devote 48, 50 minutes arguing over the meaning of a phrase that both sides say is plain and unambiguous. So how does saying it's plain and unambiguous over and over again help the analysis?
I think it just kind of is a fancy way of saying to apply it in its ordinary sense, as you would associate. If you think of hookah tobacco, you think of it being smoked. You picture people in hookah lounges inhaling a vapor or smoke and exhaling that. And that also leads me to point out that Global Hookah's own corporate representative testified below that he had referred to hookah as being smoked. In fact, he read excerpts straight from his website, southsmoke.com. He read that it heats the tobacco to vaporize the glycerin and create smoke, allows smoke to travel from the bowl to the vase, allows the smoker to blow harsh smoke from the vase, allows the smoker to inhale smoke from the vase, cools and adds moisture to the smoke, and transfers smoke from stem to water in the vase. So I think it's safe to say that in the plain and ordinary sense, or just in common vernacular term, that the hookah tobacco is suitable for smoking and subject to being smoked.
Isn't there another term to refer to if you combust something, if there's combustion and vapor comes out of it? Isn't that called exhaust?
It might be, I'm not
So
familiar
if
with.
someone wanted to specifically refer to the process of combusting something and limiting a term to that and not another way of getting vapor, you could use a different term, couldn't you? Like exhaust?
Sure.
As
There's,
opposed to smoking, which, again, I think people think a lot of times of the stuff that comes out of a fire, which is one way of using smoking. But if you look at the actual dictionaries from 1985, which I have, smoke has other meanings as well, and it has broader meanings. And you can even look up scientific journals as well that talk about smoke in a more broad sense.
yes, that's correct. And I don't have the 1985 definition, but one definition that I'd like to point out is or fume or vapor, often resulting from the action of heat on moisture, which we have here as well. So there are several definitions, and combustion is not necessarily required to make a product suitable for smoking. So this heat, this excessive heat, as I mentioned earlier, the definitions of ignite, to subject to heat or fire. And then another definition of burn is to undergo alteration or destruction by heat or fire. So here, this heat creates this smoke that the user inhales, therefore it is suitable for smoking. And then my last point I'd like to make, because the ALJ properly determined that hookah was both loose and suitable for smoking, it also properly found that the division's policy of taxing this product was not an adopted rule. So Florida courts have held that if an agency is merely
Well, in fact, it's either loose tobacco or it isn't, right? Your agency wouldn't have the authority to go back to your offices today and go and decide, well, let's go ahead and adopt a rule just to be on the safe side, and let's have a written adopted rule that we can tax, the agency can tax, the state can tax hookah tobacco. If it's not loose tobacco as intended by the legislature, you can't have an adopted or an unadopted rule, can you?
no.
So would it be appropriate to adopt a rule where you determine that the legislature clearly intended to regulate and tax this product, but they just didn't use the right words? So by rulemaking, you add the necessary words to effectuate the legitimate legislative intent.
No, I don't think so, because I think that we'd then be implementing or interpreting a statute and overstepping there and going beyond what is defined as a, just a
So
regular.
you say it's not your role to implement the unenacted intent of the legislature. That would be wrong for the department to do that.
No, not necessarily that. I'm saying that our policy here of taxing it is merely just regurgitating what's in the statute, that we tax tobacco products, which includes loose tobacco suitable for smoking. I think if we enacted a rule trying to guess what the legislature intended and went beyond that, then it would be an unadopted rule, if that answered your question properly.
Thank you.
Or it'd be unauthorized rulemaking, because you don't have the authority to bring things in subject to taxation by rule that the legislature hasn't already authorized, right?
That's correct.
And in fact, in this situation, are there any intelligible principles by which, that the division or the department could follow to expand this definition, if that were the authorization? Like, if the legislature were going to authorize you to, okay, you're going to tax certain things that meet these criteria, now go adopt a rule that matches those criteria to define what's going to be subject to taxation. That's the right way to do it, if the legislature wanted you to make a rule.
Correct.
That doesn't exist in this statute. They tell you what's to be subject to taxation, and they expect you to just to enforce it. Yes?
Exactly. In the statute, they would have given us specific authority to adopt a rule to include what we, might want to add there, but they did not do that here, and so.
So the same question that I asked opposing counsel, like, why are we even talking about this rule challenge? And if the answer is, well, for prospective sake, I'm assuming that your answer to this, so I'm assuming if we held that the division was overstepping its bounds and taxing things that weren't authorized to be taxed, and said that, okay, they're entitled to a refund, is the division going to go back and still continue to tax the same thing because that was only retroactive and not prospective?
If I understand your question, no.
Right.
No.
Is it necessary to go the extra step of having a unadopted rule challenge as like a belt and suspenders kind of thing? Is there some fee provision in play on the rule challenge that isn't in play for the refund? I'm just trying to figure out a way to explain why we're doing two cases.
We didn't bring this particular claim, we're just defending it. They challenged this rule, and we're here to defend it and say that this policy that the division has of taxing these products is not an unadopted rule, because we are merely just reiterating what's in the law, or in the statute already. Okay, and if the court has no further questions, we respectfully request that you affirm in full. Thank you.
It seems to me that your argument is, and it's not dishonorable or in any way disingenuous, but it seems to me your argument is, we don't care what the legislature intended, we're going to hold them to what they said. And courts have said this.
I think that's correct, Your Honor. Yeah.
Including in the case I cited to you. The court said, we are not concerned with what the legislature intended, because in that particular case, they could not have intended that particular resolution. But the Supreme Court of the United States said, we're going to hold the legislature, the Congress, to what they stated. Isn't it true here that the obvious intent of this statute is to tax all tobacco products that are not cigarettes? Now, I'm not saying that means you lose, because different judges have different philosophies regarding textualism versus legislative intent, et cetera. And there's the corollary principle that it has to be interpreted in favor of the taxpayer, which is not always at play. But isn't that the intent of this statute?
So I think there's a reasonable argument to take it that way, but it is confusing that if that was their intent, why did they do so for other statutes to say any tobacco? They could have easily said any tobacco in this instance as well, and they chose that limiter, loose tobacco.
Why do you think they chose that limiter?
I'm not sure, Your Honor.
What do you think is a reasonable reason they chose that adjective?
I thought, my personal feeling on it, I guess, is that that was a popular product at the time. They were trying to tax literal loose tobacco that you put into like a pipe or that you roll in a cigarette. I think that's a fair inference on that.
And so does your argument turn on the fact that there's a binding agent?
That's correct, Your
Okay.
Honor. Yes.
That's the whole thing. So if anyone wants to avoid taxation on their otherwise marketable loose tobacco, just add some sort of binding agent. Is there a level of binding that makes it not loose anymore, or any binding agent?
I can't think of a product that it's either bound or it's not. I'm not
Well,
really
that's not
sure.
your whole argument, though.
No, it's not.
Your other argument is that it's not on fire and it does not produce smoke.
Right. And there's, like you mentioned before, Judge Roberts, there are other statutes that distinguish smoking requiring burning, like the Clean Indoor Air Act, the medical marijuana statute, and the public nuisance statute.
Well, that's where you're wrong. On the medical marijuana statute, so medical marijuana, the whole point of smoking medical marijuana is to heat up the THC so that you can inhale it, so you can vaporize it and inhale it. So the smoking part of it is distracting in a way, because to get back to the response you just gave, why do you think that smoke is limited to the product of combustion?
Because all of the dictionary definitions say that smoking requires burning or
As
combustion.
definition one, but not all. There are other definitions
Right.
for the same word.
And if there's other definitions and there's two reasonable interpretations, then we're back to taxing statutes are construed narrowly, heavily.
But so, do you know what you call a word that has multiple definitions in dictionary?
Ambiguous.
Yes.
So in
Which
the-
neither one of you has said. You both have said over and over again. This plain, not just unambiguous, but plain and unambiguous.
In the briefing, I think we argued both, Your Honor. The reason for that, I think my comment, I hope, was directed to a question about whether loose tobacco was clear and unambiguous, and I think Brandy's and Grab a Leaf both said that. So that's where that's coming from. But you're right, if there's arguments both ways, this is a taxing statute. Taxing statutes are special. They're to be construed heavily against the government and in favor of the taxpayer.
So if the legislature next session just deletes the word loose and redefines the term smoking, then your product's taxable.
That's correct. And they tried to do that during the Brandy's litigation. They said a product made in whole or in part of tobacco, and then for whatever reason, they chose not to tax that product. So, a reasonable inference is if they wanted to tax it, they could have amended the statute then. They could easily say any tobacco. But as it's written, it has that limit or loose. It's a taxing statute. This has to be unequivocally contained in that statute. It's not, so this product is not subject to tax, Your Honors. I think I'm out of time. We respectfully request that you reverse the final orders in this case. Thank you.
Thank you, counsel. Thank you both for your arguments. The court's in recess.
All rise.
Pleasure to meet you. More active than I anticipated. Yeah, thanks a lot, Jeff. Be safe.